For the Q&A session, we are joined for this session by our colleague Diana. Diana, kindly introduce yourself.
Hello everyone, my name is Diana Ayuma Mulei and I'm glad to be here.
Thank you, Diana. I will now hand over to Njeri to proceed with the questions that we've received so far.
Thank you very much, all of you. Many questions coming in. We've seen questions about the marriages or about marriages. Keep them coming in. We will try and respond to all of your questions as they come in. And just to start off on the Q&A session, we had a question. If you have a joint property with a sibling or a friend, does it mean that it's automatically a tenancy in common? Now, for the first part, yes, property that is jointly owned between siblings, then that is automatically a tenancy in common. That means that everyone has their own distinct, but remember, the share is undivided because you're together on the title. What essentially that means is that once one of you passes, then if your sibling has passed, then that share devolves to their own individual estate and it passes according to the rules of succession. Part B of that question was, with a spouse, does it mean it's joint tenancy, or does it mean it's automatic joint tenancy, or does the title need to specify the details? Now, when it comes to the issue of owning property between spouses, the joint tenancy is not automatic. The title has to specifically state that it is a joint tenancy. Why this is a creation of the law? It's also an amendment to the Land Act, and it also affects the issue of succession when it comes to you benefiting on survivorship. So ideally, the former law before then was that when it comes to spouses, there was an automatic assumption on when it comes to joint tenancy. But however, that provision has since been revised, and the law clearly states that if you want to benefit from a joint tenancy, that mode of owning property, then the title has to specifically say it's a joint tenancy. Failure to which, then it's considered a tenancy in common. And then now, once it's a tenancy in common, then it devolves to the individual's estate according to the rules of succession. There's another question that came in on legally, does next of kin mean automatic succession? No, actually, a next of kin is a nomination of yourself. If you have shares in a circle, if you have maybe someone benefiting from your employment contract, then you appoint a next of kin. This is only for purposes of the person being called upon. If it's a mode of owning shares and you have already nominated the person to benefit from it, this is also another way of property passing other than by will. Then it does not mean automatic succession. It just basically means you have nominated someone who will benefit from if it is shares, if it is money market funds, you have already nominated the person who is going to benefit from that. So it is not automatic succession, but rather a way or a nomination upon which a person can get property from the estate of a deceased person other than by will. So Bilha, you will cover the issue. We are seeing some questions coming in about trusts as well. Bilha will take us up on the issues of trust, and we'll try and respond to as many questions as possible. Bilha?
Thank you, Njeri.
Yes.
I think one of the questions that has come through is whether both parties, and in this case, I think the person was referring to spouses, can create a trust. I think to clarify, it's possible for several parties to create a trust. So for instance, I can give an example. So say my parents, my mother, my father, and myself can actually create a trust. What this means is we can become the settlers to the trust, of the people donating property to the trust. So my father can donate his property, my mother can donate her property, I can donate my property, and jointly we create a trust and we determine who are the beneficiaries of that trust. So that's an example. So it could be spouses, it could be siblings, it could be any number of people, so long as they agree as to what is the purpose of the trust and who are the beneficiaries of the trust. So I hope that clarifies that. Then there was a question as to whether once you create a trust, will the property that is held in trust eventually go to the surviving children. I think here, my clarification would be, there are two forms of trust. So you can have a revocable trust and an irrevocable trust. A revocable trust means the person donating the property to the trust has a right to revoke it. So meaning that I can give my property to a trust and say that upon certain things happening, I can withdraw that donation. So if it was a property, say, that was collecting rents and doing all sorts of things, at the end of a certain period that I can't specify, I can put it in the instrument, the trust deed, that I have the right to revoke. Or if I see that this trust is not performing the things it was supposed to perform, maybe I thought that this was a structure that was going to work for me, then if so long as I have made a provision in the trust deed that I can revoke it, then you can revoke it. Then there's an irrevocable trust. An irrevocable trust means that this trust is to last for perpetuity. And I think the example I gave was when you form a family trust that you want to run for generations, that's an example of an irrevocable trust. This means at no point will my succession issues touch on the trust. So if in the case that our member has asked, what would happen if the surviving children then have access to the trust property? If it's an irrevocable trust, they will not have access to it because the trust property has been segregated from your estate. It has been completely removed from your estate. It's not a subject matter of your estate. So the issue of who has survived, who will never come up. But if we say that there's a revocation and I do exercise the right of revocation, then it means if I have made maybe provisions in my will or if I die intestate, then they may actually end up with that trust property. So those are the two distinctions. Then I think we've been asked to maybe take members through the process of setting up a trust and who are the parties involved. And here, I'll start by who are the parties involved, then I get into the process. So in terms of who is involved, as explained, using myself as an example, if I'm the one donating to the trust, I am the settler. The word there that they use is a settler, but you're basically the person giving property into this trust. Then I will choose people. So perhaps I choose Diana here and my colleague Jerry to be able to be the ones who are my trustees. In addition, so to maybe I add an insurance company or any other person that I decide to be the ones to manage this trust. So those are the trustees. Then I decide this trust I'm setting up for the benefit of my children. So then those are the beneficiaries of the trust. Then to ensure that Diana and Jerry do what I want as per the trust deed. The document, again, the trust deed is a constitution that actually sets out how do I want things done? Who are the beneficiaries? It's just very clear. It should be very clear. What are the powers I've granted to Jerry? What are the powers I've granted to my trustees so that they ensure that the objects are met? That is the trust deed that is there. If I want to make sure that they do not deviate from that, I can actually appoint an enforcer. So the enforcer is an independent party. They are not trustees. They're actually just an independent party that looks in from the outside to ensure that the trustees are doing what they are supposed to do. So I hope I have now clarified who are the parties forming the trust. And again, myself and others can come together to form the trust. Then once the trust is formed, we have a trust deed that sets out the constitution of the entity. Then we move to the next step. For purposes of a family trust, once you have registered this trust deed, you will take another step. And here you actually go to the registrar of companies and they register. They are the entity currently that has the power to incorporate trust. So you will submit your documents and they'll incorporate the trust. Incorporation means you end up with a certificate that says this is an incorporated entity. And the benefits that I had highlighted earlier, this entity can now go buy shares, buy land, open a bank account in its name. So if it was Bill Hawanjiro Family Trust, it will be a certificate saying Bill Hawanjiro Family Trust, and it trades as such. So I'm hoping that I have recaptured the highlights of what the formation is and also how you actually go about it.
Yeah,
Then,
so
sorry, go ahead.
Biha, just before we invite Diana with the rest of the questions, we'd like to cover, we saw a question on costs on wills and setting up trusts. So we've come up with a general mode. Why I'm saying general is that costs for creation of a trust or a will depend on the size of the estate. So it is prorated And once you see a lawyer, if you come to me, if you come to Bilha, we'll prorate it as from the size of the estate, and we will give you a favorable quotation. But just to start us off on a range or a figure, when it comes to preparation of wills, the cost can range anything from 50,000 and then going upwards. Now, depending on the size of their estate, the amount will increase. And now, once you have created a will, you will need a custodian for that will. If you choose that the custodian is going to be a law firm, in this case, Karanjanjenga or Bilha Kinyanjui, then in that scenario, when you are a custodian, we charge a custody fee or an annual maintenance fee. Annual maintenance fees, depending on the size of the estate, may vary anything from 10,000 shillings going upwards. Again, it will depend on the size of the estate. When it comes to creation of a trust, creation of a trust involves various stages, including incorporation, and the figure will range anything from 250,000 going upwards, again, this depending on the size of the estate. So I think that should cover it when it comes to cost. We will be glad for you to engage us on a one-on-one to even clarify or to answer any of your more questions when you're coming to create this trust or even create a will. Thank you, Diana. Maybe you can tell us some of the questions that are coming in so that we try and address them.
Okay, the first one here, someone says, I have one daughter in the UK, she's 26, and I have 5 siblings in Kenya. Can I put a will and indicate my daughter as the first beneficiary and my brothers and sisters as the second beneficiary?
Do you want to answer that?
Yes. So when it comes to creation of a will, then you are allowed, you see your siblings and also your daughter are all beneficiaries. There's a category and there's a hierarchy in which the law of succession lists the mode of or rather how dependents are ranked. So when you're creating your will, you're free to give your daughter any free property of your choice. And whatever remains after you have given your daughter, then you're free to give your siblings. So the will basically will allow you the autonomy. You get to decide, what does my daughter get? What do my siblings get? So you have the autonomy. The will allow you to do that.
Okay. And maybe to add on to what Jerry has said, even in the creation of the will, I know we had a session where we talked about dependence. So for these siblings, they're actually in the second level of dependency. And by virtue of them being in that second level, if you do not provide for them, say you're not maintaining them currently, there is no legal requirement for you to actually make provisions for them in your will. For your daughter, because she's in the first level, there's no need to make, for her to prove that she is dependent on you. So you would need to provide for her. For the second level, where siblings fall, if you're taking care of them and you do not make provisions, then they have grounds to go to court and ask for some form of provision. But if you're not taking care of them at all, then it's within your right and it's your prerogative to determine whether you want to add them onto your will. Thank you.
Okay, another question. Can a parent transfer property to his or her children directly when still alive and avoid paying stamp duty?
When it comes to the transferring of gifts, this we call them inter vivos. That is the legal term that defines these gifts that are given by parents to children during their lifetime. So ideally, what you're going to do is that once you transfer the property to either of your children, then automatically that property falls out of the ambit of the law of succession. Because as at the date of your passing, then it means that property is not free property that is available to be distributed or to be bequeathed to any of your children. So ideally, when it comes to transferring properties between parents and siblings, it is not tax exempt. It is a gift, yes, that you have given your children, but it is not tax exempt. There is a Stamp Duty Act that clearly states circumstances under which tax exemption can be enjoyed. Some of these instances are property that is being given, that is passing between husband and wife. then this kind of gift will actually be classified as a gift of love and affection. Then in those circumstances, then the couple that is transferring the gift between each other get to benefit from the law, and it's actually tax exempt. And of course, there's a procedure in which you apply for this exemption. Another scenario will be when property is passing from when property is being transferred to a family corporation. If, for example, I own a property, then I have formed a company between me and my wife and my child. Then if I want to transfer that property from me to that company, then I will apply to under the Stamp Duty Act for an exemption, basically saying that this property is just passing between me to a corporation or a company that is already owned by myself and my wife and my child. And of course, like I said, there are requirements that you need to meet. You need to provide the relevant evidence. If you're saying this person is your child, you have to show that you have to provide a birth certificate. They have to swear an affidavit saying that you are the child. And if you're saying this person is my wife, when you're applying for that exemption, then you need to provide a marriage certificate. Remember, when property is passing between spouses and you need to enjoy the stamp duty exemption, you must prove a valid marriage. You must provide a marriage certificate. Without a marriage certificate, even if you are spouses and you have been living together, or in this case, cohabiting together for quite some time, then the law is very clear of who a spouse is. They must be legally married and the marriage must be registered. So again, property between siblings does not, or from a parent to a child, does not enjoy stamp duty exemption.
Okay, thank you, Jerry. And also maybe to add on to that, given the examples that we've given of formation of a trust, you can also transfer your property to a trust, and that transfer to the trust under the Stamp Duty Act is also exempt. So that is an additional way you can plan your estate. So as Jerry has said, if it's a gift to your spouse, that's exempt. If it's a transfer to a family-owned company, that is exempt. And also if you're transferring from yourself to a family trust, that is also an exempt transaction. Thank you. Any other questions?
Yes. What are the provisions for a child with disability and for blended families with children?
Maybe I can take a shot at it. I think for a child with disabilities, this is still a child under the Act, and they still fall under the first category, which does not need for you to prove. But for instance, if a person passes on intestate, meaning they did not have a will, what would happen is, when the court is making determinations of what is the quantum to give to different dependents, I think there would be special attention paid to children who have more needs, because as I highlighted, the categories or the key things that the court looks at is what are the needs of the dependents. So if this one has more needs than another one, more provisions would be made for them if the person passed on without a will. Then I think the second part, other than the child with disabilities, what was the second part? So for blended families, I think this is an interesting question. So again, for purposes of this question, let's look at it as the blended families that the parties are married. That will make it easier. So if the parties are married, meaning that there's a gentleman and a lady, and maybe each of them came with children into the marriage, since these children were taken up by both parties as children of the parties, then they'll be treated as under the first category, which is adopted children. If you formally adopt them, then they'll be adopted children. Then they will be treated as being dependents of the party that has passed on. So assuming it's a wife that has passed on, so there's her children, and there's a children she adopted that came with her husband. So these are children for purposes of the law. So long as she took them in as her children, then they'll be treated as such. So, and then for purposes of, say, how do you, if this person did not write a will, for instance, then you'll go again to that order that I had highlighted earlier. How does the court determine who has, number one, how will they determine who is going to administer? We start with the surviving spouse. So you already have an answer there. It's a surviving spouse that will have the right to administer the estate. Then we go now to the next question. So once you have come in and you're administering the estate, how do we determine the order in which people will benefit from the estate? There's an order there again: spouse, children, and all the children there are catered for. And then now you flow down the line the second level. And for the second level, it will have to be people who actually prove, and their relatives, yes, but they have to prove they were being maintained by the deceased person. If they are not being maintained, then they are not covered. Then we have the third level, people who may not be related, but who are being maintained by the person who's passed on. So this third level of claimants, what they have to prove to the court is that for the 2 years preceding the death of this person was taking care of me and they maintained me. So I think that's the order in which it should be looked at.
Yeah, absolutely.
Okay. Other than a trust, can you speak about estate planning using a company with beneficiaries as directors or shareholders, the pros and cons of such a setup?
Okay. I can say something there. So companies are actually governed by company law.
Yeah.
So when you create a company in your lifetime and you decide that yourself, your spouse, and your children, for instance, are the shareholders and directors of that company, the law that applies to that entity is company law, not succession. What may go into succession is your share in that company. So if, for instance, this company owns land, you might be saying, this land is mine, but actually, no, it's not. The land belongs to the company. So all the shareholders of the company are the ones who determine what happens to that land. So, but my share, for instance, if I have 10 shares in this company, these 10 shares I can go to now into succession. So I can give them out in my will, or if I don't have a will, I die intestate, then they will be dealt with under the law of succession. But the key highlight here is you may organize your affairs that way, but there will not be succession issues regarding the company. The company is governed by its constitution, which is the memorandum and articles, and company's law, not succession law. What may fall under succession law is just what you own as a person. Yeah, that would be my view on the issue.
Yeah.
Okay, what happens in the event of a come we stay agreement and the partner who passes has property?
Jerry?
Yeah, so this is quite interesting because actually the way the African society is set up, we have met, we have been living together, and I have your children. And everyone knows I'm your wife. Even you are saying while you are alive, you used to claim me as your wife. But now you have passed on, and now things have become complicated. So the question is, can I claim from your estate? So there is two limbs that I'm going to answer that question. Number one, there is the issue of determining whether you are a spouse, according to the law of succession, for you to benefit under the estate of the deceased person. And then there is two, the children that came with the come we stay. So now, the children of the come we stay marriage, those ones automatically benefit in the estate of the deceased person because they are considered children of the deceased person. And children are in the what we call according to the hierarchy, they are category A dependents. Like I said, the children that either they are legitimate, they're illegitimate, they are adopted, or they came from a blended family. Then those ones are category A dependents and they automatically get a right to inherit from the estate of the deceased person. Now, when you're dealing with the issue of a spouse, and you're saying that you are in a come we stay marriage, the law before that used to recognize long cohabitation, and they used to say that if you have cohabited with someone long enough for it to establish permanency, that is now you're able to show that you've stayed with this person and have even had children with them over time, and the family knows me and I know their family, then it used to qualify under what we call a presumption of marriage. However, there was a recent amendment under the Marriage Act that now does away with the presumption of marriage. Now, what does this provision actually say, and what is now the standing of a come we stay marriage? It actually removes you from a category of being entitled to be called what is called a spouse. In that, for you to actually benefit, you being in a come we stay marriage, you would have to go ahead, even having stayed with this person the entire time, you'll have to go ahead and register a formal marriage for you to actually enjoy under the benefit of you being called a spouse and bring a right to claim in the estate of the deceased person. There is a rider on that, however. What I'm saying is that even if, for example, now you have not registered a marriage and the person has since passed on, but you're saying, I still feel that I have a legitimate claim in the estate of my husband, what you can do is that you can apply to court under what we call Section 6, what we call reasonable provision. Then the court will examine the circumstances. So basically, you are saying, I was being maintained by the deceased person immediately prior to their death. I may not be considered a wife legally, but the deceased person was maintaining me, even though I did not register a legal marriage. Then the court can consider those circumstances and actually, from the estate of the deceased person, allocate you what is called a fair allocation in terms of reasonable provision. I hope I've answered that question exhaustively, Bilha.
Thank you. Yes,
Yeah.
you did.
In case you have an irrevocable trust, how do you do amendments, probably when you need to add additionally acquired properties?
Okay. I think once the trust deed is formed, and as Diana has pointed out, it's an irrevocable trust, you can keep donating property to the trust. Actually, it doesn't mean that the property that you start the trust with will forever be the only property in that trust. So you can start off, say, even with one parcel of land and some shares. Along the way, you acquire other properties. You can keep donating these properties to the trust, and the trustees will go through the legal procedures of transferring these assets from yourself into the name of the trust. So there is room to keep adding onto the trust properties. And maybe to also broaden that question, once you've created the trust, there are some things that are left maybe to some level of discretion in terms of if there are rules that you need to come up with in order to run the trust in an efficient manner. You should be able to leave some room for that kind of thing, so long as maybe they do not touch on to the core things of who are the beneficiaries and how the trustees perhaps should manage the trust.
Yeah.
Thank you.
Oh, this is not about succession. What is the easiest way to add an individual to a title deed?
Okay.
To add an individual to a title deed, I think that may be a broad question, but
it's a broad question depending on what is the situation of the current title that you have. So that one, unfortunately, it doesn't fall under the ambit of what we are covering today, but there are definitely ways in which you can add an individual to a title deed. I suggest the person who put the comment to get in touch with us personally. We will be able to examine the particular situation according to the title that you have, and then we'll be able to provide the necessary feedback and advisement on how you can proceed. At the end of the presentation, we will be sharing our slides. They contain our contact details and information. You can reach out to us, you can email us, and then we'll be able to advise you further.
Okay, are we taking more questions?
Do you have any other?
Yeah.
Okay.
For someone with not so much and with one child, is it advisable to have a will or a trust? I would also love him to get some money when he's 25.
When it comes to creation of a will, we said a will is a legacy. It's peace of mind that you're passing down to your generation. So it does not matter whether you have one asset. It does not matter whether you have only money in your M-Pesa account. It does not matter whether you have 10% shares somewhere in a company. It just says you need to have an asset. For as long as you have an asset, then you qualify to definitely write a will. So even if you have very little assets and it does not matter the magnitude, go ahead and write a will.
Thank you.
Okay, recognition of foreign wills done in another country, what would make them invalid? And then on domicile and jurisdiction, how is domicile determined for succession purposes, and what impact does dual domicile have on estate planning?
Okay. So maybe you can repeat the first question.
They want to know about what would invalidate a foreign will and whether it's recognized in another country.
I think if a foreign will has gone through the process of being confirmed in that country, meaning that it has met the requirements in that country, then so long as Kenya has has a view that it can acknowledge and endorse that will, then it should be valid here, because the principal law that applied was a law in the foreign country. That would be my view. I don't know whether you have any addition there.
Yes, I do have an addition. When it comes to what we call domestication of foreign wills, if a will has been adjudged by a court in another jurisdiction, it is a valid will, and Kenya actually is a party to a reciprocity act, whereby if a court in a foreign jurisdiction that is within that particular act has adjudged and actually declared a will formal, then what is done is that you take that will and you come present it in a Kenyan court, and the will is actually domesticated and it will be adopted as it is. So a foreign will is valid in Kenya if at all it has gone through the particular of channels of domestication. Yeah.
Okay. Do you have any comments on the issue of domicile? I think for a will to be valid in Kenya, then the person needs to have been domiciled at the time of their death in Kenya. I think that is the guiding.
That's the position.
That's a guiding rule.
Yeah.
That if you died at the time of your death, were you domiciled in Kenya, then the Kenyan courts have jurisdiction. That's a basic.
Yeah.
If you're not domiciled in Kenya, then that becomes a different issue.
Yeah.
Okay. Can children claim their share of generationally inherited land from their parents in case the parents decide to sell it?
I'm curious as to whether when they say generationally inherited land, perhaps this is what customary land, perhaps, and ancestral land, which would then, I think then the customary law would, for instance, if there's a dispute around how that land was devolved to the next generation, and maybe they were excluded or it was something else happened to it, then customary law will be taken into account when the court is making a judgment as to how it should have been. It should have been devolved, noting that it would have to be customary land. If it's not customary land, it was just land that they acquired themselves, then the laws of customary law would not apply. Yeah.
Okay. How do you identify legit trustees?
I think this one is a complicated one, because people can change. You might meet this person and know them for many years and believe that that they will be able to do what you expect them to do. I think the conduct of the person, because people's conduct is usually very telling. So if you know a person is of good conduct, is someone who has fidelity, they're able to do the right thing, that is a good trustee. But if you look around you and realize that perhaps you're encircled by people that you cannot fully trust, there is the provision that you can actually get a corporate trustee. A corporate trustee is not going to think about, there's rent that has come here, before I send it to the children of this person, let me use it today, I'll send them next week. So you remove that angle when you bring in a corporate trustee. But if on the other flip side you have people that you can bank on, which is difficult to get sometimes, then you can make them trustees. But if you have question marks on these people, then maybe go with your gut feeling and actually choose a corporate trustee.
What is a guideline or rule regarding setting up a trust where one person is not Kenyan?
I think the law does not limit who can donate into a trust. So, as I said, a trust can be formed either by one person or by several people. So, if you're donating into the trust, there's no legal exclusion of people who are non-Kenyan. So, perhaps maybe your spouse is non-Kenyan and you both own property, whether separately or jointly, and you want to donate the property into the trust, then the law does not preclude them from donating this property into the trust and forming the trust as the settlers, who are the people donating the property into the trust.
Can one indicate that shares in a SACCO go to the family trust on their upon their demise?
I believe this is possible because, as we said, at the end of the day, you have free choice. And maybe that is what Jerry was saying. You see, when you're doing estate planning, you're actually taking time to think about what you want.
Yes.
So if you have, you can actually nominate the family trust as the beneficiary of those shares in the SACCO. So the key thing here, and I think we probably need to take away, the biggest thing we need to take away is just the thought of planning my estate, and then taking the actions necessary, whether it's a will, whether it's a trust, whether it's such nominations as you've given, actually taking those steps so that in your absence, then either your beneficiaries will not suffer, your beneficiaries will not fight, your beneficiaries have clarity as to what your wishes were.
Yeah.
Okay. A third generational trust and all beneficiaries passed on. I am left and no children and wish to liquidate it. How can this be done and it was irrevocable? It has a corporate trustee.
Actually, this then is exactly what we are saying, that once it's in the trust, there is no exit route. However, I mean, I'm usually very reluctant to give advice without seeing the instrument. It would be important for somebody to present the instrument before a lawyer, and I think Jerry and myself can do it, then look at it and actually say, are there any exit points or there are none? So it would be, on a general, there's no exit point. However, this is subject to a lawyer actually reviewing the documentation. Yeah.
So perhaps the person who wrote the comment can just get in touch with us, and then we'll be able to advise on the way forward.
Sorry, we're told that there's one person. I think
there's
who
one
wants to
person.
dial in. Okay. Maybe we can take that question.
Yes, we can hear you.
Okay, there was a question I put up about when a Chama buys property and the trustees are put in as owners, does that mean they have control of the property? And what happens when one person leaves the Chama or dies?
Okay. So yeah, so I was saying that, as I had explained, when a property is purchased by a Chama and some of its members hold the title, they're actually holding in trust. So once they're holding in trust, what happens is that they're holding in trust for the collective, for everybody in the Chama. Meaning that if say there are 10 members and there is this property, all 10 members have a tenth of that property as being their property. So what would happen is, if one passes on, their estate is the one that has the right to actually claim that portion of the property that was owned by the deceased person. So it does not mean that when they die, their interest dies. It simply means that the people who are managing their estate need to go to the Chama and claim for their Chama, for the late members' interest in the Chama. I hope that answers the question. Thank you.
Yes, we can hear you.
In the thing of blended family, you mentioned about the adoption process, when companies don't look at the adoption process for children, but then there's also where the process was done, but the parents got treated in marriage. Touch on that in terms of right to pregnancy, in terms of tested and infected cases, and also if the children are adults versus underage children. Thank you.
Okay. You want to say something? I think for the children that are not adopted, but they were being maintained by this by the married couple, then what would happen is that, remember, there's an order. There's a first order that covers children that are biological and adopted. Then in category 2, where you're required to prove that there was a level of dependency on this person, or on the fact that they were maintaining you. In category 2, there's a provision for children maintained by the deceased person. So for children that were not legally adopted, they would fall under this category 2. And since they were living with the family, their fees were being paid, etc., they would be adequately catered for. So I think that answers that portion.
Just maybe to add on it is that when it comes to blended families, and these two couples have come together, and from their previous marriage they had children, and now they have come together and contracted a legal marriage. The assumption is that the spouse has recognized these children as their own, because remember, you cannot marry their mother and not take in their children. So the idea is, if they're able to prove, if you're able to prove that indeed that I did contract a legal marriage with this person and I came with these children, then it can be said that your spouse recognized these children as their own, and they will be entitled to benefit in their estate. Do you have any more questions?
No? Okay.
Okay.
I think
So,
thank you.
Before we close off on the session, it will be interesting to note that we have received a lot of questions on intestacy. We have also seen quite a number of questions on marriages. We will be having a part B where we will demystify and we will delve intricately into these issues. Remember, intestacy, where there is no will, is where things become complicated. And in the form where we have different types of marriages being contracted, and we have different forms of families apart from the basic nuclear family, that is where complications arise. And then to add on to it, we also have relatives who are also coming in to claim in the estate, and we also have non-relatives. So just join us in the next part B. We will delve into these issues, we will answer your questions, and we will definitely shed more light on the rules of intestacy. We hope to see you there.
Thank you.
Thank you.
Sorry, just before we log off, I think we've been told that there is one other
There's one
person
question.
with a burning question.
Hello.
Hello.
Yes, I was asking,
Yes.
on behalf of group of our men, as men, we have this idea. Because this is for the men, especially, and not just affects the women also because they are our sisters and our wives and our girlfriends. Sometimes as men, we end up having sown seeds where we don't even know. Even though the kids got better known, but kids were not known to us, and they are not known to the family. And after you pass on, and that child is brought into this dispute, how do you work on this? My name is Alpha George, and I represent the men and the boys who are in this group.
Hi, George. We're actually really proud to see the boy children are well represented in this category. I was waiting for the person who is going to ask that question. So actually, we are dealing with if you've already contracted a marriage, but you have children elsewhere. Then now we are dealing with a case of illegitimate children. So now you have passed on, but the children were not provided for. In the case that you've already passed on, then if their mother comes to claim in your estate, then all that needs to be proved is that the children are actually yours or you have sired the children. So DNA tests are conducted, and if the children are indeed your children, then they have an automatic inheritance under your estate. The court will definitely provide for them. But just to avoid these kinds of scenarios, remember we said that is why it is important to create a trust or even create a will, because a will, remember, is private, and it can only be read after you have passed on. So in the case you want to provide for these children or even their mother, and outside the ambit of letting your family know that you have children outside, then you create a will or you create a trust and specifically assign to them assets or provisions that you want them to benefit under even after you have gone. I believe I've answered that question.
Maybe I can add something. I think George said that children that the person may be aware of or unaware of. So I want to highlight the ones that are he is unaware of. So if there are children that you are unaware of, I think here this is a very strong case for a trust, because when you create a trust, you have removed any and every property you've put in that trust from the ambit of succession. No succession process will be dealt with regard to the assets that you've put in this trust. So for instance, if there are some very prized properties and that you feel strongly should always be for the benefit of your spouse and children, this is actually a very strong case for you to put them in a trust, because even if, God forbid, a child appears when you are not there and you did not have any idea they even existed, they will not now come in and start and becoming a problem to your family because they do not have access to the properties that are created in your lifetime in the trust. However, if you created the trust through a will, then you're in trouble, because it means that whole will be contested by this person who actually falls in category 1 of dependency. So this, not only should you consider a trust, but also consider a living trust, which is a trust that you create in your lifetime.
Yeah.
Thank you. We okay now? Diana, we have another question?
But we need to
sorry.
close.
Sorry, maybe I can read that. So this person says this is urgent. The question on the single person without kids living abroad was not clear at all. So maybe we can respond on the question on a single person with kids living abroad. I think this was the one where they said that she was a mother who has a daughter living abroad, and they have siblings in Kenya. And I think our answer here was that the mother has the power to determine what goes into her will. And to protect her child father, it's important that she actually has a will in place or any other instrument of estate planning. And in the will, we say that the siblings that are in Kenya, they do not have an automatic right to be provided for in the will. The daughter is in category A. The siblings are in category B. Category B, what is the distinctive factor? In category B, you must prove that you are being supported or you are being taken care of by the deceased person. If you are not being supported or taken care of by the deceased person, you have no legal right or claim to actually go to court and contest this will. So if, for instance, this lady was taking care of one or two of the siblings, then those ones, she must make provisions for them in her will to avoid a situation where they want to go and contest the will. However, for the other siblings, if it's within her power, within her right, she feels she wants to cater for them, she can cater for them. I hope that clarifies the issue.
I think we're closing now.
And I think with that, I believe we have answered all the questions. As Njeri said, our contacts will be shared together with the presentation that we have presented today. And we also hope to have another session where we can engage with you further. Thank you for your time and do have a good day.
So good morning, members. We've come to the end of our webinar session today, and we want to appreciate all members who took their time to join today's session. It was very informative, and I can say even for us, we have really learned. There's a lot of many technical issues that we will also get to go back to them and learn. So we want to say thank you. For our presenters of the day, Karanjanjenga and Company Advocates, WK and Company Advocates, represented by Diana, and not Diana, by Bilha and Jerry, we appreciate the session. There are so many questions, as I can say, and most of the gray areas in marriages, and I think we'll have another session to interact on them. And to our members, you asked and we have delivered the session. We may not have answered all the questions that you really wanted us to address them today, and we want to say there will be another session where we get deeper into the issues of marriage, and especially the come-stay marriages and the families that sometimes we don't know they exist. To the technical staff, to Tech 6 Africa, thank you for hosting us. To United Women Circle staff, team behind the scenes, we appreciate. So to the members who have joined us, we have a link that we have shared on the chat. Kindly give us feedback on areas that you'd want us to address in our next session. Thank you so much.